Hello everyone. So in last class we have studied about the sources of jurisprudence. We have studied as customs as sources of jurisprudence, precedents as sources of jurisprudence, statutes as sources of jurisprudence, etc. So now we will be looking into the various schools of jurisprudence and what they have to tell. So you might be thinking that we have studied about the sources of jurisprudence, what jurists have to tell on jurisprudence. So what's the need of studying differentiating between different schools of jurisprudence? So I will tell you this by an example. So do you know what does a click mean? Click. Have you heard the word click? Click are the group of people which have some common interest, or these are some like-minded people. For example, say you are in a university and there are some group of people who enjoy listening to music, who enjoy dancing, who enjoy to do drama. So these all will form a group and they will not make other people enter into their group. So this is how grouping of people have been formed. Similarly, in jurisprudence also, there are various jurists which have grouped together relating to the similarity in their views and what they think are the sources of jurisprudence. So, the introduction to schools of jurisprudence is what we will look into. So, first, analytical school, second, historical school, third, sociological school, fourth, natural school, fifth, philosophical school, sixth, realistic school. So, we will look into it one by one. Analytical school of jurisprudence. So, remember who is the author or who is the founder of Analytical School of Jurisprudence? Of course, John Austin. So, John Austin, the father. So, what is the basic background? A law which actually exists is a law, though we happen to dislike it or though it varies from the text. So, according to John Austin, it does not matter that law which has been made is likable for the society or not. A law, if made, is a law and we have to follow it. So, the law which is in front of us is what it is. So, according to him, law in front of us, we don't have to analyze why this law has come. Just it is there and we have to follow it according to John Austin. So, next, what Analytical School of Jurisprudence has to say about jurisprudence. Law originates from state. King can do no wrong. So, basically, there is a keyword to remember this Analytical School of Jurisprudence. It is that king can do no wrong. So we have to assume that whatever king has told to his subordinates or to the persons governed, they have to follow it likably, whether they like it or not. So it is believed that in this school that no one can question the authority of the king and king can do no wrong, which means that king has the ability to think that what is right and what is wrong, and thus king will always form a law which is good for the society. It is presumed that. Third, consequences of actions have to be sustained. So it's not just that a law has been made by the king or by the state. The consequences which follow have to be looked into. How can we look into the consequences? For example, if we make a law on crime, like for example, what has been written in Indian Penal Code, but there are no penalties or punishments prescribed if we do not follow that law, then whether that law is effective? Of course not. So the consequences have to be looked into if we make a law according to Analytical School of Jurisprudence. So here king King can be substituted by state also in the present scenario and with legislature also. Legislature is also the body which makes law. Similarly, in the earlier times when we were a British colony, king used to rule us, and we had many kingdoms before that. Different names of this school: analytical school, believes to be analytical and non-flexible. Why this school is called analytical school? Because analytical literally means non-flexibility approach. So this school follows non-flexibility approach. That is, it is very rigid in nature. Positive school because it focuses on law being positive as it is. So the key word here is as it is, means the law has to be followed as it is now in front of us. Third, it is also called Austinian school. Why it is called Austinian school? Because as Austin was the father of this school, he laid a theory, command of the sovereign, which means whatever sovereign has to say has to be followed by the citizens, irrespective of whether they like it or not. So Austinian school, as Austin is the founder of this school. So this is all what is in there in analytical school of jurisprudence. So now let us look into the various proponents which have told about this school. Proponents of this school. First, Jeremy Bentham. So Jeremy Bentham is the father of jurisprudence, but he is not the father of analytical school. The father of analytical school is John Austin, and the father of jurisprudence is Jeremy Bentham. Austin is the father of analytical school of jurisprudence. H.L.A. Hart has told law positivism, analytical school as law positivism. I have told you the meaning of law positivism. It means that whatever the sovereign has told you, you have to follow it as it is. There is no analyze, one should not analyze why this law and how this law has come. Thus, this law isn't in front of you and it should be followed. So, according to him, there's no need to look into what other countries are doing for a particular situation which have arisen in a country, and same situation has arisen in India. So one, according to H.L.A. Hart, one does not need to look into the prevailing conditions of other country so as to make a formal law which is fine with the situations of our country. So there's no need to look into the various sources or various happenings of other countries, only concentrating on what the legislators have to say about law, or what they have to write about law is what law is, according to H.L.A. Hart. The third proponent of analytical school is Kelsen. Kelsen regards it as pure theory of law. So, pure, what does it mean by law being pure? It means that law should not have anything, law should not take into account any happenings which are there in the society. For example, this is what Kelsen has to say about law. He meant to say that if we think that there should be some amendments which have to be made in the present law, then that should not be there. Or we don't have to discuss, or the lawyers or the jurists or the judges don't have to discuss on what law is, whether they should just give judicial decisions on what is law at right now. So because Galson assumes that law is pure, it is free from any discussions, it is what it is. In Salmond, what Salmond has to tell about in Analytical School of Jurisprudence, he tells that rule of action, which means that it's not just that we make a law which is binding, just not just merely by saying that it is binding, it will be binding. We have to impose some legal consequences or legal implications for non-abidance of that law. So this is what Salmond has to tell, that it is a rule of action. So he focuses on action or consequences. And what Holland has to say about law. Law is formal positive, which means that according to Holland, there should be a formal structure. For example, if a king has made a law, then it should be followed by all the society, all the citizens. But that does not mean that the king should not tell that how that law has come into force. So what are the steps which have made that law? Thus, the people or citizens have the right to say that this law is not proper. It is for the king to think or to give a judgment relating to the issue in favor or not in favor. But the citizens should have right. They should know about the formal structure of making a law, is what Holland has to say about law. The next school is historical school. It focuses on history. And what is history? History is the past. So what does past teaches us? It teaches us that there were many mistakes which we should not commit in present and future, so as to avoid that the present, the happenings, the similar happenings which have taken in the past to reoccur in present. So historical school focuses on history. And what history? Law is found, not made. So what were the prevailing conditions in past have to be taken into account while making a law for the present generation. For example, let us suppose that Sati Pratha, which had been followed for time immemorial in the past, should it come back in present, and should it be legally followed now? So let us think that one day when we wake up, the legislature comes with a law, and we read a law which states that Sati Pratha has become legalized, and if we don't follow Sati Pratha, we will be penalized. So will people abide to that law? Of course not, because law should prevail to the prevailing conditions of the society now, and it should see that in the past the society was primitive, but it will not suit to the present modern needs of the society. So this is what historical school has to say. Law develops from easy grasp legal relation in primitive society, which is extended to complex modern society. So this is what we have seen just now. So it means that we look into the various customs, the various traditions, and we recognize those customs and traditions in present only if they are reasonable, or if they look reasonable in the present modern complex society scenario. So law is not a universal validity or application. Everyone develops their own legal habit and understanding. So, according to historical school, law does not have universal validity. It means that, according to this school, if there is a country and there is society 1 here, society 2, similarly n number of societies, then the law which is to be followed in different societies will differ according to the society, because different society have different circumstances and different conditions under which the people are being governed. So the law should change according to the society is what his historical school of jurisprudence says. So, according to historical school of jurisprudence, law is not universal in nature. Learning from the past takes us to future. So, we have to learn from the past observations and apply it to the present and future generations so as to come with a better law and better understanding of society. So, now let us look into the proponents of historical school of jurisprudence. The proponents of historical school, Savigny. Savigny is the founder of this school. He gave a theory which is a very famous theory of Volksgeist. What does Volksgeist mean? It means common spirit of people. So according to this theory, which we will be learning in further classes in elaborate. So according to Savigny, theory of Volksgeist means there is some common spirit of people, the common thing which makes them binding, which keeps them interactive, which keeps them interdependent. So that common the spirit of people should be looked into account while making any law, is what historical school has to say. So just by making people agree to a particular law is not what is to be done. We should look into the common notions which are followed in the society, the common spirit, which has to be taken into account. What Maine has to say about in historical school. So the second proponent which will be studying in historical school is Maine. Stages of development, division of society. He laid emphasis on the stages of development. So there are various stages of development of law and society. In the past, we were primitive, but now as we are gradually becoming complex, we are attaining complexity, now we are moving to in a very fast speed to the modern society, and we are progressing. So we have to look into the stages of development in the society and the division of society. It's not just that all the law is universal in nature. So we have looked into what historical school have to say about law. So historical school has told that law should not be universal in application. It depends on the society. So similarly, what Maine has told is the same. He has told that law depends on the division of society. The third proponent is Montesquieu. What Montesquieu has to say. So first we should know that Montesquieu was the first person who actually propounded that, he actually said that law is not something which is made. It should be taken, it should take into account the prevailing conditions of society, generations, the problems, etc. So the idea the first came into mind, it was in the mind of Montesquieu. First one to talk about this school of law and society should be together. Then fourth is Pushta. Neither government or individual make law, both have to be together. So according to Pushta, it's not that the government makes a law and that law has to be followed by citizens, but the individuals and government have to work together to make a law which is to be followed, so that there is a correlation established between government and individual. So this is what proponents of historical school have to say about law. Sociological School of Jurisprudence. This is the third school which we are studying now. The main subject matter of sociology is society. So, society. Sociology is the study of society, human behavior, and social changes. So, you all have studied sociology, or you all be probably studying sociology in your classes of PLLB now. What is sociology? Sociology is the study of society, the interdependence of men with each other, the human behavior. It's what we all study in sociology. So, the sociological school of jurisprudence advocates that the law and society are related to each other. So, it means that if law is at this stage, then society cannot be at this stage. Okay, so it has to be at the same level, same equal footing. So, according to sociological school of jurisprudence, the law and society should be at the same level. And let's take for example Sati Pratha. So when Sati Pratha was introduced, it was introduced when the society was much primitive. And if the similar law is made in the present modern society, then do you think it will be followed? Obviously not, because the society has now progressed to this extent. The law is here, so there should not be a gap between law and society. So this is why Sati Pratha will be, if someone makes a law on Sati Pratha, then we will probably think it's a stupid law or absurd law. So this is what sociological schools tells about. Now let us take another example. Intergalactic trade. Intergalactic trade. So this is a very fancy term, because now it's very it's not so much possible to imagine that there will be a trade between galaxies, because now man has gone to the various planets and he is exploring space, but it is very difficult. So it will be take very long time for this to happen. So here we have what we have done. We have made a law which is much above than the society, which is much below. So there is such a gap between. So this should not happen. The law and society should be at equal footing. This school argues that the law is a social phenomenon because it has major impact on society. So what does social phenomena mean? Social phenomena means whatever law does to the society, it will have an impact on the society, and whatever happens in the society will make a law. So both are related to each other. So it's a social phenomenon. Law is dependent on society. Societal conditions is what historical school has to tell. What sociological school has to tell. So proponents of sociological jurisprudence. First, Ehrlich. Ehrlich is the founder of sociological school of jurisprudence. His theory is living law with society. So he considered law as an organism. What does an organism need to sustain? He needs air, water, land, or the various conditions which help in sustaining life. Similarly, if we consider law as an organism, it means that it has to get certain essential things. It has to take certain essential things to live. So it can derive it from the society. So law is an organism which depends on the society according to Ehrlich. The second proponent which we'll be studying is Roscoe Pound, which is a very famous proponent. He gave a theory which is called social engineering. So what is social engineering? We will learn in later classes that social engineering gives some certain presumptions. This theory given by Roscoe Pound have certain presumptions, approximately 6 to 7 presumptions. So which states that for an individual to exist in a society, he should behave nicely with other individuals. So what is the relationship between individuals, how he should help other individual, what are his obligations, his duties, his rights towards other individual, is what is the concept of social engineering. Third is Auguste Comte. He gave a theory which is called Auguste Comte, organic theory of society. He gave a theory, organic theory. So, as Ehrlich has considered law to be an organism, similarly, we can say that who? Auguste Comte. Auguste Comte considered society as an organism. So, consider this has to be a society which is an organism according to Auguste Comte. So there are many conditions which affects the society. What are those conditions? Like war, external aggregation, virus, etc. This can be, society can be influenced by all these conditions. So society will also be influenced by law. So Auguste Comte considers society to be an organism, whereas Ehrlich considers law to be an organism. Now let us look into what other authors have to tell. Duguid considers that Duguid gave the principle of social solidarity. What does social solidarity means? Solidarity means interdependence of man on each other. So in a society, it's not possible that an individual is able to manage all the needs which by his own. He depends on other members of the society. So according to sociological school proponent Duguid, he gave a theory, social solidarity, which means that there is interdependence of men on each other. Now, let us look into another proponent, Ehring. What Ehring has to say? Ehring gave a theory which is known as social utilitarianism. What does social utilitarianism mean? Let me give you an example. For example, in the past years, past years, you have come across a major thing which happened in India, which was, of course, vaccination. So, what was the need of vaccination? The need was that the society needed vaccination. The first need of which was taken into account was of society as a whole, which needed vaccination for its citizens. Similarly, so first example we can take of vaccination in social utilitarianism. Second, we can take of lockdown. So you all know that there was a long time which in which we were locked down. So in order to protect the society from the spread of coronavirus, the government, what did the government do? It locked down the country. So it was a need of the society. So the society need was put in the front space so as to tackle it more efficiently, and the society was of paramount importance at that time. So this theory is what is social utilitarianism theory. Then next school is natural school of law. Many students have confusion as to what is natural school of law. So let me explain you this by an example. Have you heard a case, Queen versus Dudley Stevens? In this case, there were three persons who were on the verge of death because their ship has broken down. When a ship breaks, all the food commodities, all the ration, all get destroyed. It's all get. So what they will do now? What is the mode of survival? Because they have to remain in sea for so long. There was no help which they can get at that time. So two of the persons they thought which were slightly better in health, and the third person was a child which was very ill. So they thought that let us do something, because this way we all three will die. So ate they killed the person and they ate the meat and drank the blood of that person. So what exactly made them do this? So they gave a excuse that the natural instinct, that is survival of the fittest, and self-preservance is what made them do this. So when they went out, when they came back to their country, they were tried because, and they told in defense that they had to do this because of the theory which states that the fittest only have to survive, and also to preserve themselves they have to think first of themselves and then of others' life. So this is why they killed the innocent boy. So what do we understand by this case? We understand that there are certain natural instincts which a man when he is born has. So these instincts is what is laid into the sociological school of jurisprudence, in natural school of jurisprudence. So natural school is a philosophy of law that forces on the law of nature. This school of jurisprudence represents the belief that they are inherent laws that is common to all societies. It is known by different names which we'll be studying now. So natural law is also known as the moral law, divine law, the law of God, law of reason, law of nature, universal law, and unwritten law. So you probably have heard that some people say for something that it is natural, like it is universal, it is divine rule. So what all we consider divine is what all we see in natural school of jurisprudence. The school of thought tells us that the law is rational and reasonable. Natural law proposes that laws are a radical progression from morals. Therefore, actions that are considered to be morally wrong will be against the law. So, it considers that law is a progression toward from morals. So, if something is morally wrong, should it be made legally wrong? So, let's take for example, if there is a law which if there is no law made on a certain subject, then whether and it is legally not, it is morally not, it is morally very wrong to do that thing on that subject. So whether a law should be made so as to make that thing legally wrong? Of course, yes. So laws are a radical progression from morals, and we need to stop these radical progression. So this is what natural school of jurisprudence has to tell. Let us take an example. You all have heard about Section 377. In past, there were certain discussions in order to whether the Section 377 should be penalized or not. So what do you think about that? What does Section 377 tell? It tells that homogeneous marriages and the same gender relationships should not be allowed. So why do you think that people thought that same gender marriages should not be allowed? Because they thought that it is a divine rule that the same gender should not have relationships with each other. So this is what natural school of jurisprudence has to say. Phases of natural school of jurisprudence: ancient period, medieval period, Renaissance period, and modern period. Ancient period focused on nature as the source of natural law. Then medieval period was focused on church. Renaissance period. In Renaissance period, there was fall of church or the decline of church. Decline of church. And in modern period is what we see the law in the modern present society. So these are the phases of natural school of jurisprudence. Now the fifth school which we'll be studying is philosophical school of jurisprudence. This school is also known as moral school. So the philosophy, what does you mean by philosophy? Philosophy is why, how, and when. It means that why the law has been made, how the law is being made, and when it will come into force. So the basic aim of this school is it focuses on why, what, and how. For example, we can look at Uniform Civil Code. So why the law of Uniform Civil Code has come, and what are the legal implications of Uniform Civil Code, and how will it impact in the present society is what this philosophical school of jurisprudence studies about. The basic aim of this school is that it tries to extract the reasons why which particular law has been established, which I have told you earlier. So the reason, they basically think that law is the product of human reason and the ultimate aim is to raise and praise human identity. So this considers, for example, let us take there are individuals which are present in a society. So society contains a group of individuals which we can tell n number of individuals. So they all have different egos in the society, egos of their own. So how will the society take into account all the egos which different individuals have? So they will look into what individual 1 has to say and what individual 2, and similarly what individuals n have to say about a particular law. So for this condition to not to happen, we will treat individuals, we will make a general will of individuals, and which will be equated to the general will of society. So by this, individuals' will and general will of society will be same. It investigates the purposes for which the law is created. All the investigations are there in philosophical school of jurisprudence. Investigations. What do you mean by investigations? For example, why the law has been made. For example, we can take family law. There are certain conditions which by which a family, the marriage institutions, or whether there is a will writing or similar other conditions, how those conditions are governed is what we study in that. So we investigate that in certain cases the head of the family does not give his property to the persons who are legally eligible to get. So for that, to counter that problem, we have made a law which is written in the family law, which states that in the will these are the people who will get the benefits of the will and these will not get. So by investigations we have come to a situation in which we have made a law governing that situation. So this is all what is studied in philosophical school of jurisprudence. In philosophical school of jurisprudence, a law has to be reasonable and sound for it to be accepted. The philosophical school of jurisprudence lays emphasis on the reasonability of law. It means that any abrupt law or any stupid law will not be considered as law because the society will not accept it. As we have seen that a society does not accept unreasonable or abrupt customs, similarly society will not accept abrupt laws as well. So a law has to be reasonable and sound for it to be accepted by the society as a whole. So for this acceptability, we have to go into the philosophy of law, the facts of different cases, as well as the conditions which are prevailing in the society. So proponents of philosophical school. Now we will look into the various proponents of philosophical school. The first main proponent is Hugo Grotius, who is considered as the father of this school. So the father of philosophical school is Hugo Grotius. Then second is Immanuel Kant, he states that ethics and law are not the same. So it's not that. If we consider philosophy, we consider all the morals, the ethics, the common ethics and the principles. We considered law as law, and ethics and law should be separated. This is what is propagated in this school. Ethics and law to be separate is told by Immanuel Kant, who is a proponent of philosophical school. Hegel. What Hegel has to tell. Purpose of law is to reconcile different egos of society, which I have told you earlier. So we have taken an example in which there is a society and there are many individuals in those. So a society as a whole will have a different ego and the individuals will have different. So all those have to work coherently, enable to get a better law and better understanding with each other. So purpose of law is to reconcile different egos of the society. Now the fourth proponent is scholar. What scholar has to tell in philosophical school is that there is no universal body which is suited for entire. So we have looked into this in historical school as well, which states that there is no universal law which has to be followed in the society. The law depends on the society. It depends on the, if there is society A, if there is society B, the law will be different in both the societies. Similarly, law depends on the countries as well. A law will be different in country A, and the law which is followed in country B will be different. So a similar notion is followed in philosophical school of jurisprudence, in which it is stated that there is no universal body which is suited for entire nation or entire society. Now the last school which we have to look into is the realistic school of jurisprudence. A realistic school is a type of school which focuses on decisions. The name obviously suggests that the decisions, it focuses on decisions. And what are decisions? Decisions are the judgments which are pronounced by the courts. These judgments can be given by the judges of conventions, or the judges of lower courts, or the judges of higher courts, or any courts per se. But this school focuses that the law is not what is discussed, and what the morals, law is not according to the morals, or morality is not law, ethics is not law. Law is something which is pronounced by the judge, or a legal judgment, order, or decree is what is law, according to realistic school of jurisprudence. They believe that law is an official action. So any discussions, any deliberations are not accounted as law. Only official action in the form of order or decision is what is considered to be a law. So this school is known as realistic because it focuses on approach that studies law as it is in the actual working and its effects ahead. This school rejects traditional definition of law and also avoids any dogmatic formulation and fully concentrates on decisions given by the courts. So this is what I have told you in this, that the realistic school lays emphasis on the judicial decisions and not on the morals or ethics which govern the society. Proponents of realistic school. So the first and the main proponent of realistic school is O.W. Holmes. He is the founder of realistic school. The spiritual father of this school, he believed law is what court do and not merely say. So let's, for example, there are 7 judges bench and there is 13 judges bench. So what the 7 judges have to say about a particular case is not to be studied. What they have to say is not to be studied. That the study should be on the ratio decidendi of the case, which means that the thing which has to be studied is what is decided and what is written in the judgment, rather than what judges have to say or what should have been the law. So written law is what is law, and decision is the outcome of any case. And what Gray has to say, Gray is also a proponent of realistic school. Gray, law is only law if given or made by judge. He also lays importance to judge. So the judicial decisions pronounced in the court are what is considered as law. The judge can be of any court, lower court, Supreme Court, High Court, of conventions, of treaties, etc. Judge can be an arbitrator too. So any law which is pronounced by any judgment which is pronounced by the judge is considered to be a law, then what Levinley has to say in Realistic School, law is what is researched by lawyers and presented and agreed by judges. So it's not that only judges make law. Before judges make law, how do they come that this fact is relevant or this fact is not relevant, or what is the prevalent circumstances which has made the case to come into picture? So this is all what is discussed by the lawyers. So lawyers point out deficiencies as well as things and circumstances which has led to a particular case, and they discuss with their clients and they point out the conditions. So law is what is researched by lawyers and presented and agreed by judges. So both have a role to play in the lawmaking or judicial decision. So lawyers and judges both participate in judicial decisions. So this is what Realistic School has to tell about. This is all what we have studied in this school, in these schools. So now I have given you basic understanding about the different schools and what the different jurists have to tell about these schools. But this is only an overview. In detail, we will study about the analytical school in our subsequent classes. Till then, okay. Take care and revise. Bye.